Good morning, everyone, and welcome to the final installment of the Workplace Wednesdays webinar series on the PRO Act and the changes that are coming to labor law in the near future here. So in this last installment, my partner Keith Eastland and I are going to talk about sort of what changes are definitely coming, what changes are maybe coming, and what you all should do about it. The main theme from this series, I think, should be pretty clear, is that change is definitely coming. There's no question about it based on the fact that there is now Democratic control of the White House. There will soon be a Democratic majority on the NLRB. We have the PRO Act in Congress. Right now, it has passed the House and it is in the Senate. So we know change is coming. The only question is how much. So like I said, we'll talk today about the changes that are definitely going to happen. We'll talk about the changes that may happen. And we will talk mainly about what it is that employers can do to prepare for the new environment that is on its way while there is time. And that's the most important point of today. There is time right now for employers to take proactive steps to be ready when these changes do finally come. Before we get into that though, a quick update on the PRO Act. So the PRO Act, as we've mentioned in previous webinars, is currently in the Senate, in committee. Nothing has happened since it went to committee legislatively, which happened on March 11 after it passed the House on March 9th. But that does not mean that all has been quiet on the PRO Act front. According to a report from The Intercept, I think published just under a week ago, Senator Chuck Schumer, the Democratic majority leader in the Senate, had a conversation with Richard Trumka, who is the president of the AFL-CIO. We've mentioned Mr. Trumka a few times on these webinars. And Senator Schumer apparently told Mr. Trumka that he will bring the PRO Act to the Senate floor for a vote if he can get at least 50 co-sponsors on the bill. Currently, there are 45 co-sponsors. Not surprisingly, it is essentially all Democrats, so 44 Democratic senators and then one independent senator who is Bernie Sanders. There are still 4 Democratic senators and one independent senator who caucuses with the Democrats, and that's Angus King, who have not signed on to co-sponsor the bill. But if and when they get those 5 to sign on, they will be bringing it to the floor for a vote, according to the report based on what Senator Schumer said. The article also details how organized labor is putting pressure on the 5 remaining holdouts to be co-sponsors, which includes mobilizing constituents in each of their states to flood them with voicemails, encouraging them to support the PRO Act and things of that nature. And then the article also recognizes that the PRO Act likely goes nowhere with the filibuster, and organized labor is prepared to tackle that, but first they want to get all of the Democratic senators and the 2 independent senators on board before they tackle that. So that is where the PRO Act currently stands. Keith will talk a little bit more about that later. I am going to talk first about the changes that are definitely going to happen in the coming years. This relates to the conversation on the webinar last week about the pendulum that is going to swing back in favor of organized labor and employees and away from employers. This is the natural pendulum swing that happens when there's a change in control in the White House. But this, what we expect is that President Biden's board is going to reverse many of the Trump board decisions that reversed President Obama's board's decisions. So we're essentially going to swing back to where we were when President Obama was president in a lot of ways under the NLRB case law. And the rules and standards that we expect to go back into place are definitely going to provide more protection to employees and unions and it's going to allow them to engage in conduct that is currently not protected under the law passed by President Trump's board. So most of you probably were, you're very familiar with the way things were under President Obama's board. That's what we're headed back to, where we need to tiptoe around more, parse policies and things of that nature. So these changes are going to happen. And as we discussed last week, there's several areas where we expect the Biden board to return to the pre-Trump board precedent. There will be others as well, but these are the main ones that we have been focused on. And the main one, I think, for everyone on this call right now is we're going to return to the old standard on handbooks and workplace policies. So the standard is going to go back to you can't have a rule if a employee would reasonably construe the language of that rule to prohibit them from exercising their rights that are protected by the National Labor Relations Act, which are their rights to concertedly voice concerns about their wages, benefits, hours, terms and conditions of employment. So if a rule can be reasonably construed that way, then it's going to be considered unlawful. And as we've mentioned before, reasonable is not a reasonable employee who probably does not have these thoughts at the forefront of their mind. Reasonable is the NLRB General Counsel, the NLRB's regional directors, the NLRB's trial lawyers. That's who's going to be reasonably construing these rules. So we're going to go back to that policy. We are almost certain. We also expect a return to expanding what is protected and what employees can be disciplined for while they are engaging in protected activity. So we will return to a rule where we evaluate sort of the totality of the circumstances to determine whether conduct employees engaged in while also engaging in protected activity remains protected, using profanity, threats, harassment, things of that nature. We will return to this standard from a more pro-employer standard where we could enforce rules against threats and violence and harassment and profanity while employees were engaged in protected activity. Now, the rule we expect to return is the old rule, which basically says that the employee needs to engage in sole violent or egregious behavior that they're rendered unfit to continue employment, but also with the acknowledgement that the types of things discussed when they involve terms and conditions of employment engender, ill feelings and strong responses. So sort of an acknowledgement that employees can cross a line that they probably wouldn't otherwise be able to cross in most areas of the law. And, we discussed last week some of the things that employees have gotten away with under that standard. So we will be returning to that. We fully expect the board to return to the standard that employees can use their employer's email system to engage in union and other protected and concerted activity. We expect enforcement again of policies that prohibit all photographs, videos, recordings being taken in the workplace under President Obama's board. That those types of rules were found to be unlawful because employees need to be able to sort of take evidence of unsafe working conditions, other things that they want to concertedly address. So a policy outright banning all that stuff is likely to be enforced as unlawful. We expect that the rule that many employers might have that matters discussed during an investigation are confidential while the investigation is ongoing. Those are, again, going to be unlawful, and they'll need to sort of look on a case-by-case basis to see whether it's appropriate to maintain confidentiality in an investigation. And we also expect return to the joint employer standard that was passed under President Obama's board, where you can be considered an employer of a group of employees if you only indirectly control them, or if you have the ability, typically contractual ability, to exercise control over them, even if you haven't done so. You'll be considered an employer under the act. This often comes up in sort of the franchisor-franchisee context, but it can come up in other contexts as well. So we expect that will be the new standard going forward. Now, why are these changes definitely going to happen? It's really quite simple. Unlike the PRO Act, Congress doesn't need to be involved here other than appointing the board members to the board. Once that happens, the board has the discretion to make these changes through its decisions, through its case law, once an appropriate case is brought before them. So it is really just a matter of time for these changes. The first thing that needs to happen is President Biden needs to appoint a Democratic majority to the board. Currently, the board has 3 Republicans, 1 Democrat, and 1 open seat. One of the Republicans' terms expires in August, and so we expect over the next year probably for 2 board members who are Democratic to be appointed, and at that point they will have a majority, and when the cases are brought in front of them, they will be able to make these changes. So again, it's simply a matter of time. We know it's going to happen. So what should you do to prepare for these changes? This is really just about being proactive because we know it's going to happen. So now is the time before these decisions start coming down to take these proactive steps. And the main ones that we think all employers should be taking right now is first and foremost, reviewing their handbooks, reviewing their policies, sort of considering whether they want to NLRB proof them. And we think that consideration ought to be framed in the context of the PRO Act potentially coming down the line as well, where there is enhanced penalties on employers for failing to comply. You can now be fined, for having an overbroad handbook policy. So review your handbooks, focus on the policies that in the past the board has found to be potentially problematic. And those are, some of the ones we discussed earlier on recordings and things of that nature, but they're also, your conduct policies. The board in the past has had a problem with employers asking their employees to be courteous or respectful. And they'll say, because you're not always courteous or respectful when you're engaging in protected activity. So those are the types of things that you should at least look at and decide whether it's a risk you want to take going forward or not. And now is the time to be having that discussion and reviewing those handbooks and policies. We also recommend training frontline supervisors on sort of the new world that will be coming here, where employees can seemingly cross a line that many employers don't want crossed when they're engaging in protected and concerted activity, so that the supervisors are aware of what is protected, concerted activity, and they avoid making emotional decisions if somebody, for instance, happens to berate them or swear at them or call them a nasty name. The obvious and natural reaction would be to part ways with that employee, but we want to train them if in any way what they're doing is protected and concerted. There needs to be a discussion about that before that decision is made. They shouldn't just react immediately and make a decision that could have long-term consequences. And then third and relatedly, we think it's important that businesses, organizations ensure that HR is involved in any decisions involving discipline, and particularly involving termination, because of the fact that now a line that previously we've been able to uphold in the last 4 years can be crossed again. HR needs to be able to look at this stuff, they'll have a good idea of what the law is in this area. They can get their legal counsel involved if need be and make an informed decision. And the decision may be to fire that employee, but at least there will be a discussion about the risks associated with that. And we think if you take these proactive steps right now, it really is going to help prevent an organization from inadvertently engaging in an unfair labor practice and potentially even sparking organizing activity, because there's going to be an awareness of what the law soon will be. And obviously in the meantime, we will keep you all updated as the pendulum sort of swings back in the direction that it was before the Trump board took over. So those are the main things that we think employers can do to address the changes that definitely are going to be happening. It's just a matter of when. And I'm going to turn it over to Keith now to talk about the changes that may be coming and what you can do to prepare for those as well.
Great. Thank you, Patrick. Good morning to everyone. I guess good morning to my any of you out there that are Michigan fans that stayed up late to watch that tough loss in the tournament. They had a good season, but hopefully you're back in action this morning. And for you MSU fans out there, I guess you're probably just fine with that. I want to talk a little bit this morning kind of about the PRO Act, where it stands. Patrick gave us a great update. But really, the focus of my few minutes with you this morning is going to be on, what are the risks that this all means or that poses to your organization, and what are some of the things that we as Miller-Johnson's traditional labor practice group want our clients to be thinking about potentially doing, as like Patrick mentioned, time is on your side right now. And if this passes, it could go pretty quickly, and you may be playing catch up. And, we feel like our job here in this final installment is to make sure that you folks have thought about what things you should be thinking about and making the right decisions for your organization. So the PRO Act, I'm not going to talk about the sort of parade of horribles, if you will. We've already covered all of those things, up to $50,000 fines, all of those injunctions. But those are all in the prior webinars. And if you haven't had the opportunity to look at any or all of those, I would encourage you to go back and review those if you're looking for detail on the specific provisions of the PRO Act. But I will tell you, Miller-Johnson, we've got access, like most major law firms do, to legal service and research tools that include artificial intelligence, AI. And on one of the previous webinars, we had run the PRO Act through that predictor, if you will, the artificial intelligence predictor, headed at a 41% chance of passing. I can tell you that I ran it this morning, and Scopus Labs, they do the predictive analytics on this, has raised it to 54% chance of passing. And so I'm not telling you it's certainly going to pass, but I'm telling you lots of people and lots of analytics are suggesting there's a good chance that the PRO Act is going to become the law. And that's pretty dramatic changes, not pretty, very dramatic changes in labor law. And pretty concerning if you want to protect your culture and you don't think, if your organization believes that you prefer not to have outside entities involved with your employees and with your decision-making process. So keep that in mind. Now, well, what about the filibuster? I don't have a crystal ball, but I can tell you this. It seems to me that there's going to be some legislative changes coming. And it's probably going to look maybe a lot like the PRO Act. And my guess is there's going to be fines. There's going to be things that are going to up the ante, so to speak, for all employers, both union and non-union, in terms of tilting the playing field toward organized laborers, because that's a policy choice that is being made. And it's something that we have to deal with as representing employers, your law firms. We have to deal with those things. So I would encourage you to think about this, and obviously you're here, so you already are thinking about it, but think about how we message this throughout your organization and what steps you can take to prepare. So next slide, please, Patrick. And how to prepare one more, please. So what's the PSA, public service announcement, I would say here? When I sat down and thought about what we want to say to you guys at the end of this series, I think the most important thing here, and I know most of you are HR folks, VPs, although I do know we've got some CFOs, CEOs, presidents, C-suite type folks on the call as well. But I think it's important that you get your leadership in your organization to understand the risks and challenges, not just in what's coming, right? Patrick's right. There are certain things that we know are going to go back or going to be the way they were, or maybe even worse from an employer's perspective. You can prepare for those and you can change those. But there are additional things that may give this real teeth. You really want to be in a position where you have an employee handbook, you didn't update it, and all of a sudden, hey, there's a union sniffing around, or someone just submits it to the NLRB, and there's up to $10,000 or up to $50,000 fine for every 8A1 violation. So every, they go through and pick handbook out 6, 7, 8, 9 policies that they believe a reasonable employee would think would interfere with their rights. Therefore, you violated the act. Now you're looking at 7 times 10,000, 70 grand, 7 times 50,000, 350 grand. That's real money, and that matters. And not to mention the things that can be used for in terms of if there was ever an organizing drive, and that's something that you didn't, your organization didn't want to occur. So there are things that are going to happen. I think one of the biggest things that if I was saying, okay, how do we get our leadership to care about this, right? We hear about it in the news. You say, well, this is the PRO Act. It may or may happen. Well, there are certain things that are going to change that Patrick mentioned, and there are certain things that may change. But I think the biggest sort of the elevator pitch that I would give to why someone should care about this is, number one, changes and risks to your workplace culture, okay? What your workplace culture is up to you. You know your people, you know what makes you tick, you know what distinguishes you from competitors, you know why people want to work with and for you, right? You know how to retain talent, attract talent, you know why you lose people, okay? There's a certain way to operate. We're lawyers, clients decide these things. A lot of clients decide we don't think that having a union would help us. We think that structure, that us versus them mentality is not a good thing. And you have every right to believe that. And if that's what you believe, and you believe that that is your culture, well, I'm here to tell you that these changes, including the PRO Act, are going to tilt that field in favor of third parties, including labor unions here, right? That's what we're talking about, to get a foothold and maybe risk your culture, maybe get a change in how your workers, your employees think about this. And that is the risk from an organizational perspective, okay? And you're going to have little time to respond if these changes hit, right? Now is the time to be proactive. So these labor law changes create a risk to your workplace culture. There's going to be little time to respond. We've got a limited period to be proactive on certain things to give us the maximum protection to take these proactive steps to minimize risk. We're going to have fewer tools, rights, and options to respond. In the event your organization likes to its status as a non-union entity, and I get it that some folks are perfectly fine and have great relationship with unions. I'm not saying that's good or bad. I'm just telling you, if your organization chooses and prefers that non-union direct ability to communicate with employees, and you want to preserve that culture, when all of this passes, there's going to be fewer tools, rights, and options for you to respond. And I've already talked about the increased risks and penalties. So those 4 bullet points, I think, are sort of the elevator speech of why do we care about this? Why should we invest time and resources thinking and making changes in this area? Shouldn't we be worried about other things? All right. So let's talk a little bit about why risk to your culture, your organization's culture matters. Right? Step back and remember why employees, choose to work for you, choose to stay for you, want to be involved. Why do they do a good job? Typically, it's because you've empowered and engaged them, right? They feel like they're part of a team. If you've been to Miller Johnson seminars in the past or other workshops, what do employees care about the most? It's not typically good wages and benefits. Yeah, they want market wages. They want to feel like they're getting fair wages and good benefits, but that's not always at the top of the list, right? People want to feel part of a team. They want to feel like they're in the know, that they're valued, that they're not a cog in the machine, right? They valued as a human, valued as a worker, valued as a person, family, and part of a shared mission, a goal, right? And you achieve that through engaging your employees, right? That's how you maintain your productive, positive cultures that work for you. That's how you improve efficiencies. That's how you attract and keep talent, Okay. And it keeps everybody focused inward, right? Miller Johnson's a great place to work because, man, we pulled together and did some great stuff during COVID. That was awesome, right? That's one way to look at it. What's the other way to look at it? Well, Miller Johnson sucks because, hey, no one talked to me during COVID and I didn't talk to my manager. And, what happens when we don't see people and they make decisions and we get emails? Your workers get an email from someone that says, here's the new policy. They haven't talked to them in person in 2-3 weeks, maybe a month. Haven't seen them. Or when they do see them, they're in a mask. Well, I like to think that it's like almost like, well, wait, people can grow horns, right? If I don't see someone and they're doing something that I'm not quite sure I like, all of a sudden I start to think bad things about them, right? I'm not engaged with my managers or supervisors as a worker, and that can easily get me kind of spinning out of control, going down a path that maybe I wouldn't otherwise do. Okay. And that's why this impact of coronavirus pandemic and the different social changes we're seeing, right? When you step back and look at our world is different now, right? People feel like, hey, some of these structures are, not fair. They're not getting a fair shake. I mean, we saw people for different causes engage in activism, go take it to the streets, do these things. So there's this underswell, I would say, of this, hey, are we being treated fairly? This questioning, right? And you couple that with coronavirus and how that's impacted our ability to communicate with our workers, our employees, and there's strain. And I will tell you, I'm involved in organizing drives, and what I'm seeing is this COVID is really creating an opportunity to stress those good employee engagement relationships, right? Think about what you've done. I'd ask you, think about what you've done in the last year for employee engagement. I submit that a lot of our clients, a lot of organizations around the country, employers, have kind of done whatever it takes to stay above water, right? You've been trying to figure out what executive order is going to change, since March of last year. Where, okay, this week is a governor going to change it? What's that going to mean? How am I going to get my masks? What am I going to do? Do I have to take temperatures? Now what do I have to do? If an employee tests positive, what are the protocols? What's the CDC saying? What's Kent County Health saying if you're in Kent County, et cetera, right? So we have all this stuff that we've been focused on, that we've had to focus on for COVID. Well, what falls off the plate, right? Employee engagement. Have we done a survey? When's the last time you did feedback for the managers? Have you had your recognition and awards programs, right? Have you had the fun events? You probably have a company picnic or something. We can't do any of that. What have you done to engage your employees? My guess is it's less, maybe more. Then maybe you're all over this. Fantastic. But I offer this as, things that you should be thinking about, because now's the time to do these things. Because if this law changes, PRO Act gets passed, we're certainly going to see board swings the other way. A lot of this stuff, if you're fighting to preserve your workplace culture and you believe that ought to be without a union, you're gonna make a lot more headway with the employees if you start doing this stuff now, rather than when something hits and all of a sudden we're scrambling and our rights and ability and tools are less or restricted, and it's a lot harder to fight off an outside party trying to get their nose under the proverbial tent, the camel's nose under the tent, proverbial. Anyway, so, expanded communication programs. These are things we would encourage you to think about. Ensuring all shifts have access to HR and resources, right? Is our HR person working from home, or our HR staff working from home? Because you can, and what does that really mean? Well, and as you all know, you have your manager and your supervisors. Some of them are really strong. Some of them are not so strong or weak. And they have different pluses and minuses. And HR can be that sort of additional face of the employer. Well, if HR is not around, at the factory, at the plant, whatever, on site, or not available, that can also strain the relationship. So employee engagement, positive employee engagement, absolutely critical. And part of that is the supervisors, right? You know who your superstars are in the managerial staff. You know who maybe needs some work. but they need to understand that, right? Because think about it even from their perspective, right? Your supervisor is, let's say you're in a manufacturing setting. Well, you're working your tail off. You're trying to fill holes when people get contact traced and they can't come to work. And, you know, maybe you're having trouble getting people to work because our government's decided it makes sense to pay them $1,000 a month to stay on unemployment. All of these stresses of the frontline supervisors, in addition to maybe your production is up because you're an essential worker and maybe you're making toilet paper, right? So these stresses, so what falls off their plate? When's the last time we talked to the managers about engaging their employees, those types of things? Do they understand the importance of that right now? If we haven't done that, we ought to think about it. And then are we including employee engagement strategies in the decisional process, right? So many times when we get involved in a union organizing campaign for a client that, you know, prefers to remain union free, they will say, they being the union will say, or the employees will say, hey, I think we need to have a union because I don't think we have a voice. I don't think anyone listens to me. I don't think my manager gives two rats, you know what, about me. And it's evident because they just keep throwing and stuffing policies and rules down our throat. No one ever asks me, hey, how can we improve this process? What can we do to make things better? Because no one cares about me, right? And frankly, if that's an organization that does that, you know, we have a saying as labor lawyers, like, well, sometimes employers might deserve a union because a union would be important because they are treating their employees right. Maybe they don't have a voice. So what are you doing to ensure that your folks are, in fact, being heard? Now, that doesn't mean you have to do what they say, but at least, and one, they may have great ideas. Two, hearing them out will help them because even if it's not the decision they like, you know what their concerns are and you can address it and you can message it appropriately. So again, positive employee engagement. All right. So what other things does Miller-Johnson, do we think you should take to prepare to manage these risks of the changing labor law environment? If it were me, if I were in your shoes, or if it was my business, I would say, have we done a self-assessment? I would say to my team, okay, leadership team, where is our exposure? Where are our risks, and how do we address them, right? What is our plan, right? And that can include review of pay, benefits, and other policies, right? Are we in line with market? What kind of benefits are we providing? Are there issues and policies that are a concern to our workforce? If so, maybe we have to do that. Maybe we just have to manage the communication better. Or are there things we ought to do to change them? Risk assessment, top to bottom buy-in, right? So, this goes from the deck plate supervisor all the way up to the CEO president level, right? We've got to have buy-in that this is a risk. We need to assess it, and we need to stay on top of it. We need to dust off our training. We need to get our supervisors involved. We need to figure out our communication strategies, and we need to figure out what is making us successful and keep doing it or change what we're doing to become even more successful. Or maybe if you're not being so successful, what things you can do. And that's where this training supervisors, I think, matters. Patrick mentioned it before. I think there's two components to the training of the supervisors. One is sort of the employee engagement component and why that matters. And the other is the nuts and bolts, right? Hey, we don't want to step in it and have a $10,000 fine because our supervisor doesn't know what protected concerted activity looks like, and the employee calls them an a-hole in connection with protected concerted activity, and that's actually protected under the new NLRB decisions that will be coming down the pipe. So, but then also for unionized employers on the call, right? There are changes in how we deal with everyday things, how we process grievance, how we respond to information requests, the employer's rights to take certain actions under a contract. All of those things are things that the supervisors need to be aware of so they don't step in it. Okay? Other things we should be doing, looking at, making good employment hiring decisions. I know this is tough. Some of you may be rolling your eyes saying, Keith, are you kidding me? We'll take anybody with the pulse that we think will do a good job. True, I get that. It's tough to get workers in certain segments, markets, and certain people would prefer to stay home as long as the unemployment extension benefits continue. Those are all challenges. But we still got to make sure you're making good employment hiring decisions, right? It's real easy to hire someone. It's real difficult to set them up and march them out if they're not performing and they shouldn't be employed by you. And it creates a lot of risk along the ways. And let's be honest, you get one rotten apple in that barrel and that can start to poison everything, right? And maybe they're having their head turned and they start questioning all these things, and you overlay the COVID world where people may be more susceptible to feeling like that they don't have a voice, or that maybe they're not being heard. You get the gist. And the last thing I would say before I wrap up is have a plan. Okay, develop a plan. Many of you may have this already. Maybe you need to dust it off and fix it. But the level of detail of that plan is obviously up to you. The perfect plan is break the glass, right? If, somebody, the union or someone starts saying, hey, I think we need a union around here because we're not being treated properly, and you don't want that, you have every right to communicate lawfully to your employees about why that isn't right. But if it gets to card signing or something more where you may have an election, you don't want to be scrambling to figure out what all these things are, where our risk areas are, how to shore those up, right? You want to already know that, and then you want to have specific things that you will do and who will be responsible for them. So you have a feel for what that's going to look like. Because remember, we're going to go back to this, quickie election type regime where you're going to have just a few weeks, before you're going to have a union election if you're being targeted. And if you don't have a plan in action with responsibility assigned and people don't know what that looks like, then you're going to spend a lot of time figuring that out when you could be spending that time talking to your folks, making sure that they understand all of their rights and making a fully informed decision. So have a plan, I guess, is the point there. And let me say one last thing, on that. Let me give you an example, I guess. So the PRO Act, as it's currently constituted, would say that if half of your employees had signed a union card and there's an election, and let's say you have a plan and you communicate and your employees decide, you know what, we think we're better off without a union in a secret ballot election, and you win that election. Great. This is fantastic. We've preserved our culture. We've won. Let's go have a drink and a dinner or whatever, celebrate. Okay. Now, what if you have a handbook that has an overbroad policy, or one of your supervisors does something during the organizing drive that is unlawful under a new board rule, expanded board rule? Okay. Under the PRO Act, if it gets passed and half of your employees had signed cards with the union, and you win the election, the union loses the election, if they can go back and show that there was objectionable conduct that impacted the election, the law would impose the union on you, even though you won a secret ballot election. And I share that example because to me that's an attention getter, right? So what you're saying, Keith, is I may have all of these risks that Patrick talked about, being proactive. You say, well, maybe I'll just wait till the PRO Act passes. Fine. But if you get in that situation and it passes, I mean, think what I do for a living, right, as a labor lawyer changes, right? Now we've got to make sure that as a lawyer, I got to make sure my clients, if that's the position they want to take, their supervisors know not to step in this. Because the last thing we want is to win the election, but then have a supervisor or a policy undo it all. So there you go. I said I wouldn't talk about parade of horribles. I only talked about one. No. With that, I have nothing else to share other than to wish everyone a great Wednesday. I guess we can stick around if there are any questions. Or Patrick, do you have anything to add? Anything that I missed or you should clarify?
No, all set. Thank you, everybody, for tuning into this series. And we are always here if you have any questions or need any help in this area.
Absolutely. Absolutely. Great point. Yep. Whatever we can do, reach out to Patrick, to me, to your labor lawyer that you work with ordinarily, and we're here for you.
All right. Thanks, everyone.